Welcome to this video where we unpack the hidden cost of switching to temporary humanitarian visas and why many long-term residents are unexpectedly losing their path to settlement. We will explore how long residence rules work, how humanitarian schemes are classified, what a switch can do to your continuity of residences, and practical steps you can take if you are affected. Along the way, we will examine legal fairness issues, compare options, and provide an action plan that you can follow immediately. We will also include interactive quizzes to help you check your understanding. Let's begin by setting the context, and then we will move smoothly into the core policy mechanics. During global crises, governments often introduce temporary humanitarian routes. These routes are intended to provide immediate protection, but they are typically not designed to lead to permanent settlement. Recently, long-term residents in the UK discovered that switching to the Ukraine Extension Scheme, a humanitarian pathway, resulted in losing the time they had accumulated toward indefinite leave to remain under the 10-year-long residence route. This happened because humanitarian visas are often categorized as non-qualifying leave, akin to a prolonged visitor status, and therefore do not maintain continuity for long residences. Before diving into details, we will outline today's agenda to guide you through the key issues and solutions. The agenda today covers 6 parts. First, we will explain the long residence trap and how the classification of humanitarian visas can reset your clock. Second, we will analyze whether this is merely policy design or effectively a penalty. Third, we will compare legal challenges with practical solutions. Fourth, we will present an immediate action plan. Fifth, we will summarize key takeaways and warnings for all migrants navigating complex pathways. Finally, we will reinforce learning with quizzes. Under the 10-year-long residence route, individuals who maintain continuous lawful residence for a decade may qualify for indefinite leave to remain. This route acknowledges integration, community ties, and stability. However, humanitarian schemes are commonly categorized as non-qualifying leave. As a result, time spent on such schemes neither counts toward the required 10 years nor preserves the continuity of prior lawful residence. The practical implication is that switching from a qualifying route to a humanitarian scheme can reset the residence clock to 0. A recent example involves individuals who moved to the Ukraine Extension Scheme and later realized their previously accumulated years no longer counted. We will now move from this structural understanding to a decision map that visualizes the risk points. This flowchart begins with the question of whether to switch to a humanitarian route. If the answer is yes, the next branch evaluates how close you are to completing 10 years for long residences. If you are within 12 months, the risk is high, because the humanitarian route can break continuity and cause accumulated time to be lost for the 10-year purpose. The chart recommends obtaining advice and, if possible, remaining on or returning to a qualifying route to preserve continuity. If you are not close to the 10-year mark, the next decision is whether you have a viable qualifying route, such as a skilled worker or family route. If you do, switching to that qualifying route is recommended, which restarts the relevant 5-year or similar qualifying period but keeps you on a settlement track. If you do not have such an option, the humanitarian route may be necessary, but you should plan an exit strategy because it is non-qualifying leave. If you decide not to switch at the start, the safest course is to stay on a qualifying route to maintain continuity. The diagram also highlights that policy changes can occur after a switch, so ongoing monitoring is essential. Long residence rules require continuous lawful residence for 10 years without a break in continuity. The government's position is that time spent on a humanitarian scheme is not qualifying and interrupts continuity. The timeline example shows a person starting lawful residence in 2012, reaching 9 years by 2021, switching to a humanitarian route in 2022 due to crisis, seeing formal policy clarifications in 2023, and facing an unsuccessful settlement application in 2024 because the switch broke continuity. The controversy intensifies because many people switched under stress and without clear notice that the exclusion would apply, leading to fair notice concerns. With that understanding, we will contrast legal challenges with practical steps. On the left, legal challenges may invoke Article 8 of the European Convention on Human Rights by emphasizing private life, integration, and the absence of a meaningful home elsewhere. They may also raise fairness and non-discrimination concerns regarding retroactive effects or lack of notice. The advantages include the possibility of broader, systemic relief if a court finds the policy unlawful or disproportionate. However, litigation can be time-consuming, expensive, and has uncertain outcomes, especially because governments argue humanitarian schemes are distinct from settlement routes. On the right, the practical approach focuses on immediate action, switching off the humanitarian visa and returning to a qualifying route such as skilled worker or family, even though it restarts a new qualifying clock. The benefits are greater control, predictable requirements, and a defined path to settlement, balanced against the downside that previously accrued long residence time is generally lost. Your first step is not to wait. Evaluate your current leave and whether a qualifying route is available to you now. If you can, switch immediately to a skilled worker or family route to avoid wasting further time on a non-qualifying scheme. From the point of switching, carefully document your residence, employment, and relationships to maintain strong evidence of continuity. Before making any further changes, consult an accredited immigration advisor or solicitor, because small details can have major consequences. Additionally, prepare financially and practically for the new qualifying period, such as the 5-year timeline for a skilled worker route. Finally, monitor policy updates and keep records of the guidance in effect at the time you apply, as policies and their interpretations can evolve. Question: does time spent on a temporary humanitarian visa typically count toward the 10-year-long residence route, or preserve continuity of previous qualifying residences? Options: A. It fully counts and preserves continuity. B. It is usually non-qualifying and breaks continuity. C. It counts only if you are within 12 months of 10 years. D. It depends on whether you had a job offer. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Time on a temporary humanitarian visa is typically treated as non-qualifying leave and breaks the continuity needed for long residences. Therefore, it does not count toward the 10-year requirement, and previous qualifying residences may be reset. This is why switching can be so costly for long-term residents approaching the 10-year mark. This table summarizes common routes. The long residence route leads to settlement after 10 years of continuous lawful residence. Humanitarian schemes are usually not settlement routes and are classed as non-qualifying, meaning they do not count toward long residence and can break continuity. Skilled worker and family routes lead to settlement based on their own timelines, typically 5 years and 5 to 10 years respectively, provided conditions are met and continuity is maintained. If you switch away from a qualifying route to a humanitarian scheme, you should expect continuity for long residence to be broken. The central lesson is not to assume that a temporary humanitarian visa will preserve progress toward permanent settlement. Before making any switch, obtain reliable, accredited legal advice. If you have already switched, act quickly to move on to a qualifying route so that you do not continue losing time on a non-qualifying pathway. Accept that the long residence clock has likely been reset and focus on a route designed to lead directly to settlement, even if it means starting a new timeline. Next, we will map a typical journey to make the reset effect more tangible. This sequence diagram illustrates interactions among a resident, a qualifying route, a humanitarian scheme, and the settlement clock. Initially, the resident remains on a qualifying route for 9 years, and the settlement clock increases accordingly. A crisis prompts a switch to a humanitarian scheme. At that point, the settlement clock for long residents reflects a break in continuity and a reset. Later, the resident moves to a skilled worker route, initiating a new 5-year qualifying period for settlement under that route. The diagram annotates the humanitarian period as non-qualifying leave and emphasizes the importance of building evidence of continuity once back on a qualifying route. Question: with 9 years of continuous lawful residence, you switch to a temporary humanitarian scheme for 10 months, and later move to a skilled worker visa. Which option best describes your position for long residence? Options are A. Continuity preserved with 1 year left. B. Humanitarian months do not count but continuity preserved. C. Continuity is broken and the 10-year clock resets with a focus on the skilled worker 5-year route. Or D. You can combine humanitarian months with skilled worker time to reach 10 years faster. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. By moving to a non-qualifying humanitarian scheme, continuity for the long residence route is broken and the 10-year count resets. Afterward, the practical solution is to remain on a qualifying route like skilled worker and complete its 5-year pathway to settlement. This content is for general information only and does not constitute legal advice. Immigration rules change frequently and outcomes depend on specific individual circumstances. You should consult a qualified and regulated immigration advisor or solicitor before making decisions about your status. To summarize, humanitarian visas are generally non-qualifying and break continuity for long residences. Switching late in your journey can erase years of progress. The most actionable step is to move as quickly as possible to a qualifying route and rebuild toward settlement. While legal challenges may exist, they are uncertain and slow, so a practical plan is essential. Keep detailed records and consult qualified professionals before making changes. Thank you for watching. If you found this helpful, please like, share, and subscribe for more clear explainers. We would love to hear your experiences and questions in the comments.